Hello, I'm Attorney Carol Avard, and I'm going to prepare you for your hearing before the Administrative Law Judge. Your hearing will be very informal and behind closed doors. Your attorney or representative will be with you and a person who records the hearing. There may or may not be a vocational expert who will testify as to whether or not there are any jobs that you can perform based on your medical limitations and past work skills. There may also be a medical expert at your hearing, paid for by the Social Security Administration. These medical experts may be asked if your condition meets any of the medical listing criteria used to determine disability. You are also welcome to bring your own vocational expert or your own medical expert to testify at the hearing. You must bring a picture ID with you to the hearing. You may bring a witness if it is necessary, but do not bring a witness just to corroborate what you will testify to. Witnesses are required in certain cases, but not in all cases. For example, a person who has seizures will want someone else to testify about these seizures. People with mental impairments who have difficulty expressing themselves may want a witness. Children should have witnesses. People with severe memory difficulties may want to have a witness. All witnesses will need to be prepared for the hearing in advance. They will be told to sit outside the hearing room and will come in only after you testify. Judges may do this to see if their testimony will be different from yours. Generally, most judges do not want witnesses because some hearings are scheduled every 30 minutes to an hour, and it will have an effect on the judge's ability to hear all the cases planned for that day. If your hearing runs over the scheduled time, your attorney may ask for a supplemental hearing at a later date. If you cannot remember certain things like dates, you should tell the judge your memory is bad, and the best you can do is just estimate when something occurred. Never make up an answer if you are not sure of the answer. You should show respect for the judge and dress appropriately. Obviously, if you show up in shorts or jeans, that would be disrespectful. However, do not overdress because you are not applying for a job, but rather you are applying to receive disability benefits. Just be casual and be yourself. If your disability prevents you from setting your hair or putting on lots of makeup, don't get someone else to do it for you. If you have difficulty getting dressed, bathing, say so at your hearing. Always arrive at the hearing office at least 30 minutes before your scheduled hearing. Wait for your attorney to talk to you. Note that your attorney could be in another hearing, so just be patient and wait for the attorney to meet you. If you have any new evidence, please try to give it to your representative at least 10 days before the hearing. You can bring it with you to the hearing, but it is unlikely most judges will read it on the day of the hearing. Try to get all evidence to your attorney 10 days before your hearing. You will be asked by the judge if you drove to the hearing. If you have difficulty driving due to your medical condition, be sure someone else drives you to the hearing. You may not be disabled if you can drive a long distance without taking a break to alleviate your pain. This may be considered evidence of your ability to work as a taxi driver. When you arrive at the hearing office, you will be scanned for metal to determine if you have any dangerous weapons, knives, or guns. The questions you will be asked at your hearing cover every medical or psychological problem you have, no matter how slight, since the date you became disabled. It is the combination of these conditions which determines if you are disabled. This also includes side effects from medication. Many medications say on the bottle, do not drive, do not engage in activities that require alertness, or avoid hazards. Make a list of your medicines and take it to the hearings. List any side effects you have, such as drowsiness, dizziness, fatigue, nausea, or headaches. Ask your attorney what your date last insured is, because you will need to prove you were disabled before this date and not after that date. If you do not have medical records before your date last insured, you will not be found disabled. Remember to testify about what your limitations were before your date last insured. Make sure you have a complete list of all doctors who treated you before the date last insured. Also, bring witnesses who lived with you and observed your behavior before the date last insured. Review your exhibit list carefully and make sure your file contains all your medical records. You will be asked about your past work in the 15 years before the date you were disabled. You need to know your job titles and approximate dates when you did each job. Do not list jobs lasting less than 3 months. We must prove you cannot return to your past work and any other work. It is more difficult to prove this if your past work was highly skilled, because you will be able to transfer skills to other work. It is also more difficult to prove you cannot go back to work if your past work was very light in terms of light lifting. Think about what parts of your past work involved heavy lifting. If your past work consisted of a combination of jobs, then it is a composite job, and this type of hybrid or composite job may not be considered past relevant work at all. It is more difficult to prove you cannot go back to work if you did a lot of supervisory work, since you may be able to delegate some work to others. If supervision was performed only occasionally and not frequently, then it may not be considered or mentioned. You will be asked about your education. If you did not complete a certain grade, then you need to say that you did not complete that grade. For example, if you dropped out of the 10th grade, you need to testify you only completed the 9th grade. People who completed only lower educational grades had more difficulty performing many jobs. If you only got a GED and not a formal high school diploma, say that, because they are not considered equivalent. If you were in special classes, you need to tell the judge that. If you have been working during your period of disability, you must produce a document of your gross wages and the dates you worked. Sometimes it doesn't affect your disability if you earned $1,070 or less a month, or if you stopped work within 3 months due to disability, or you stopped work within 6 months because other workers had to assist you or share your job duties. If this is the case, ask your attorney for a form for your employer to fill out confirming these facts. Even if you worked longer than that, sometimes a trial work period is allowed. Ask your attorney about this. If you cannot read or write, that eliminates a large number of jobs you would otherwise be eligible for. Tell your attorney and judge if this is an issue. For example, are you unable to read street signs? If you are not working, you may wonder how a judge determines you are disabled. The judge may ask you about your activities around the house and other daily activities, because these activities may show that you can do other jobs. For example, if you can cook 3 meals a day, why can't you work as a cook? Some people can cook with help from other family members, or they can cook for a few minutes using the microwave, or they can cook using the stove if they can take frequent breaks. If you can do large loads of laundry, why can't you work washing clothes for other people? If you can clean the house every day, why can't you work as a house cleaner? If you drive many miles to the doctor's office, why can't you work as a taxi driver? Therefore, you must talk about your limitations doing any of these activities if you have such limitations. It is your limitations that are the primary concern of the judge. The judge wants you to give him or her your best estimate in minutes, or hours, or days per week, or per month of how much you can lift, or how long you can stand, or sit, or walk. Also, do you need to elevate your legs above chair level? If so, tell the judge for how long. Do you need to rest in the morning and also in the afternoon? Tell the judge for how long. Do you need to lie down in the morning and afternoon? For how long? Do you require a cane to walk on even surfaces? How long can you concentrate on a TV or a newspaper or book when you are in pain? How many minutes? What memory problems do you have? Can you remember two-step simple instructions without writing them down? For example, if you can lift 10 pounds, the law says you meet the lifting requirements of a sit-down job. If you cannot lift more than 8 pounds, you would not meet the requirements of such a job. Also, if you can sit for 2 hours, then alternate sitting and standing, you may be able to do some work. However, if you can only sit for 30 minutes to an hour, and then must alternate with standing, you may not be able to do most jobs. If you need to rest in the morning and the afternoon for more than the number of breaks most employees are given, for example, for more than 15 minutes in the morning, 15 minutes in the afternoon, and 30 minutes to an hour for lunch, you may not be able to do most jobs. If you are required to elevate your feet above chair level, most jobs will be eliminated. If you are taking naps that last longer than the typical 3 breaks most employees are given, most jobs will be eliminated. If your pain interferes with concentration so much that you cannot focus on a TV program, book, or a newspaper, it is not likely that you would be able to work at any job. If your concentration difficulties also affect your memory, you need to talk about what happens. For example, if you cannot remember simple instructions like 2-step directions to an address, or even a simple telephone number during the time it takes you to find a pen and write it down, this will be a significant problem. You must provide numbers to the judge. If you do not know exactly how long it takes before you need to take a rest from a sitting position or a break from a standing position, do not say you don't know, but rather say what your best estimate is. Numbers must be estimated for each functional limitation you have, so that proper and complete hypothetical questions can be presented to the vocational expert who will attend your hearing. For example, the judge may say to the vocational expert, if we have a person who must alternate sitting and standing every 30 minutes, elevate her legs for 40 minutes, or lift only 5 pounds, will there be any jobs available for such an individual? If the judge does not have any numbers to put next to each one of your limitations, the vocational expert either will not know how to answer the question or will testify there are millions of jobs across the country for such an individual. Your attorney will give you a form that contains a range of limitations any person can have. You must have your doctor complete the form. Give it to your attorney to give the judge so it can be used when hypothetical questions are presented to the vocational expert at your hearing. Please do not lie or exaggerate about your limitations. Your judge will look at your testimony and compare it to what your doctors said in their medical records. If your limitations are not consistent with the medical records, you could be found not credible. Ask your attorney for forms to take to your doctor describing your limitations. If you have difficulty sitting for the length of time your hearing lasts, you need to show the judge this is a problem for you by either standing up or asking the judge if you can stand up. If you have problems using your hands or your fingers, this may prevent you from doing a variety of different types of jobs. If you have these problems, describe the difficulty you had completing many of the forms the Social Security sent to you. How long did it take you to complete these forms? Did anyone help you do it? For example, you may have a neck condition with pain radiating into your arm and hand, or you may have diabetes with neuropathy or numbness in the hand or fingers. If you cannot use your hands or fingers, there may not be any unskilled work available for you. If you have pain, you may be asked to rate your pain on a scale of 1 to 10, with 10 being the most severe. An 8 would be very severe and would be expected to interfere with most work. A 6 could also interfere with some work. You must be honest about your pain levels. You should also the fact that if your medication eliminates your pain, then this may be some evidence that you are no longer disabled. If your medicine provides temporary relief, then it would depend on the length of time you receive that relief. If the medication completely eliminates the pain, but you have other side effects, the side effects alone may be disabling. For example, if you are so drowsy that you cannot concentrate or pay attention, that would interfere with most jobs. If you cannot walk for any appreciable length of time, that too may affect the ability to work. For example, if you cannot walk up to 1 block, that may be a problem. If you can only walk about 50 feet and then you need to rest, that would present a problem for most jobs. Some judges like to ask what you do from the time you get up in the morning until the time you go to bed. They also like to know about your social activities. For example, if you go out to dinner or socialize, some judges think that shows that you are not in any pain, or they may conclude that you certainly can sit, stand, and walk without any major difficulty. If you are traveling around the country, you will need to explain how long you can sit in a car or a plane without experiencing pain that causes you to change positions. If you have mental limitations such as anxiety or depression, explain in detail how many, in terms of numbers, anxiety attacks you have during the day, each week, how many minutes or hours the attacks last, and the symptoms, for example, sweating, rapid heart rate. Talk about what you need to do to recover. For example, do you go into a room and shut the door? If you are depressed, explain what symptoms you have, how long they last, and what you do about the symptoms. For example, if your depression results in a loss of energy, how long in terms of hours are you sleeping during the morning and or the afternoon? How does it affect concentration, attention, socializing, and getting along with people? Do you stay in the house? How long do you have periods of depression? Always try to put numbers on your limitations so proper hypothetical questions can be presented to the vocational expert by the judge and your attorney. If you have problems with alcohol and drugs and they affect your ability to work, you may not be found disabled. If your medical records mention that you have taken alcohol and drugs, your doctors will need to complete a drug and alcohol form, saying whether it is material or not. Ask your attorney for the form. If you have not been in treatment for a long time, for example, 6 months or more, you may be sent out by your attorney to see a doctor for a medical evaluation. All forms that you take to your doctor must be returned to your attorney immediately. The judges prefer to have all forms and medical records 10 days before the hearing. After your hearing, it will take up to 2 months or more to get a decision on average. Shortly thereafter, you may get a check sent to your bank account. If you had a workers' compensation case or other public benefits, it will be subject to an offset on your Social Security disability. This may hold up a decision on your case unless you obtain a printout from the insurance company or agency showing how much money you receive from month to month or by settlement. Any workers' comp settlement, if it is not written off over your lifetime, will likely result in an offset on your Social Security. Make sure before you settle your workers' compensation case that your workers' comp attorney includes this paragraph in your settlement agreement. Never sign an agreement that does not include this paragraph in it. Some judges may ask you to amend your onset date. There are many reasons why you should not do that, so this needs to be discussed privately with your attorney before making a decision. If you have any additional questions, ask your attorney or representative. Thank you for your attention and good luck.